Mr. Kok Heng Leun.
In introducing this proposed bill, the Minister for Law has stated that the purpose of this bill is to enhance the fairness of existing procedures and to ensure the accuracy and equity of the outcomes in the criminal justice system. To this end, amendments such as the introduction of video recording of the statement of suspects who have allegedly committed rape offences, as well as to prevent defence lawyers from questioning complaints of sexual and child abuse offences on their past sexual history and behaviours, are aligned with the principles outlined by the Minister and are most welcome. I will focus on a few proposed amendments, which I would like to seek clarifications or reconsiderations after my consultations with some NGOs. I will first start with Clause 7 of the bill, which introduces video recording of statements made by suspected of committing rape. The NGOs I spoke to welcome the introductions of video recording of suspects' statements as a step towards reducing the incidence of false or involuntary confessions arising from threat, inducement, or promise. However, a few concerns were raised as to whether the present amendment sufficiently protects the integrity and evidentiary value of suspect statement taken via AV recording. Mr. Speaker, in order for the court to be able to assess the demeanour of the suspect and whether the statement made by the suspect was voluntary, it is insufficient that only the statements given by the suspect is recorded on video. Other safeguards must also be put in place to ensure that the video recording does not give a misrepresented picture of the suspect's demeanour or interfere with the evidential value of the recording. One such safeguard is to ensure that the entire interrogation process or interactions between the police and the suspect be recorded on video. In situations where the threat, inducement, and or promise may have been communicated to the suspect prior to the taking of the AV recording, but are not recorded, the purpose of the video recording of the statement of the suspect is defeated. Another instance, if there have already been multiple rounds of pre-questioning and interrogation prior to the taking of the AV recording, research studies have shown that the suspect might appear far more callous and unremorseful when their statements are taken via video recording thereafter. As such, the recording of the suspect's statement after such intensive interrogation may not provide the court with an accurate picture of the suspect's demeanour or his voluntariness in making such a statement. Moreover, there are several technical aspects of the conduct of the video recording that, if not undertaken, may compromise the accuracy in the assessment of the demeanour of the suspect. Consider a situation where the video frame is focused only on the suspect's face and not on his other body parts. The suspect's facial movements on camera may suggest that he is calm, but his body movement may suggest that the suspect is operating under distress, but such signs of distress may not be captured on video recording. Thus, under such circumstances, we may not be capturing the accurate assessment of the suspect's demeanour, or make a finding as to whether the statement was made by the suspect voluntarily. It is also important that the safeguards be in place to ensure that the video footage will not be tampered or ill-edited, such that important or material portions of the AV recording are inadvertently cut off and not provided to the defence. As such, I would like to ask the Minister what are the other safeguards and procedure, such as whether the camera will only focus on the suspect person or will also focus on the indirect interrogators, that will be established alongside the use of AV recording to ensure that the AV recording scheme does not give a misleading account of the suspect, which may in turn prejudice the suspect. I also hope that the Ministry will continue to expand the scope of the offences where video recording of statements, especially for serious offences which carry severe punishment such as life imprisonment and capital punishment. Now I look at Clause 6 and 77 of the bill, which permits the recording of a statement from a vulnerable victim. I'm heartened to see that the government is taking such steps to protect the interests of vulnerable victims and to support them through the investigation process. I understand that investigators are now allowed to take statements from such vulnerable victims via video recording, and that video recorded witness statement scheme will be implemented in stages. I have 2 points to raise on this scheme. The first is that I would like to know how the government intends to implement the scheme in stages and the related timelines for its implementation. And the second point which I want to raise pertains to a concern which Aware has raised in its submission on this specific video recording scheme of the statements of vulnerable victims of sexual crimes. Based on Aware's working experience with vulnerable victims who have been sexually assaulted or abused, many of such victims may be reluctant to speak about their experience out of fear and embarrassment. The knowledge that they might be filmed while recounting their experience might cause them to feel intimidated or be less willing to share sensitive details via video recording. The use of video recording to record statements of vulnerable victims might potentially be counterproductive to ensure an accurate assessment of the facts. Under such circumstances, would the interviewer of a vulnerable victim be able to exercise his or her discretion, even if a police officer may think it is necessary, to not video record the statement, but instead record it in writing under the proposed Section 22(5)(c)? I hope that the Ministry can set out how it seeks to address such a situation where the victim might feel uncomfortable to go on video to record his or her statement.